Welcome to Uber School's comprehensive guide on informed consent, confidentiality, and privilege. I'm Pete, and I'm joined by my esteemed colleague.
Crash here, folks. And let me tell you, we're about to dive deep into the murky waters of psychology ethics. It's going to be a wild ride, so strap in.
That's right, Crash. This topic makes up 20% of the California 2019 Psychology Law and Ethics examination, so it's crucial that our students grasp every detail. Let's start with informed consent, shall we?
Absolutely, Pete. Informed consent is like the foundation of a house. Without it, everything else is just going to come crumbling down. So what's the first thing our future psych superstars need to know?
Great analogy, Crash. The first crucial aspect is understanding the capacity to consent. This involves assessing a client's ability to comprehend, appreciate, reason about, and express a choice regarding the proposed treatment. It's not just about age, it's about cognitive function and mental state.
Right on, Pete. It's like when I'm out bow hunting. You got to be able to read the signs and know if your target is in the right position. Can't just shoot blindly, can ya?
Well, that's an interesting way to put it, Crash. But yes, assessment is key. Psychologists need to consider legal criteria for competency, use appropriate cognitive assessment tools, and factor in age-specific considerations. Mental health conditions can also impact consent capacity.
And don't forget about documenting all this, folks. It's like leaving a trail in the woods. You got to know how to get back home, right?
Absolutely. Documentation is crucial. Use standardized methods, meet legal requirements, and address ethical considerations in your notes. Now let's move on to assent procedures. This comes into play when working with clients who lack full capacity to consent.
Oh boy, this is where it gets tricky, ain't it? Like trying to explain to a deer why you're in its territory.
I suppose. Anyway, assent procedures involve following ethical guidelines, using age-appropriate strategies, properly documenting the process, and balancing assent with legal guardian consent. It's a delicate dance, especially when conflicts arise between client assent and guardian consent.
Speaking of tricky situations, did I ever tell you about the time Marcus Cooper tried to get assent from a grizzly bear? Now that's a tall tale if I ever heard one.
Crash, focus please. We're talking about real psychological practice here. In cases of assent-consent discrepancies, psychologists must apply ethical decision-making models, consider legal implications, and use effective communication strategies to resolve conflicts.
Right. Sorry, Pete. Got carried away there. So what's next on our Uber School journey through the informed consent jungle?
Well, we need to discuss the actual informed consent process. This includes developing comprehensive documents that cover all essential elements required by law and ethics, meet state-specific legal requirements, and consider readability and accessibility.
The paperwork. The bane of every outdoorsman and psychologist alike. But I guess it's necessary, huh?
Absolutely necessary, Crash. And it's not just about the documents. Conducting effective, informed consent discussions is equally important. This involves clear communication, addressing all client questions and concerns, considering cultural factors, and properly documenting the conversation.
All right, Uber School students, pop quiz time. Which of the following is not typically included in an informed consent document?
Good idea, Crash. Here are the options. A, risks and benefits of treatment. B, alternative treatments. C, the psychologist's personal phone number. D, limits of confidentiality.
Take a moment to think about it, folks. We'll reveal the answer after this short break. Don't go anywhere.
And we're back. The correct answer is C, the psychologist's personal phone number. While contact information for the practice should be provided, giving out personal phone numbers is generally not appropriate or necessary.
Right you are, Pete. Now let's move on to the next big topic, confidentiality. This is like the sacred oath of psychologists, ain't it?
Indeed it is, Crash. Confidentiality is a cornerstone of the therapeutic relationship. It's crucial to understand how to maintain confidentiality, its limits, and HIPAA compliance requirements.
HIPAA? Is that like the hippopotamus's cooler cousin or something?
Not quite, Crash. HIPAA stands for the Health Insurance Portability and Accountability Act. It's a federal law that provides data privacy and security provisions for safeguarding medical information. But before we dive into HIPAA, let's talk about maintaining confidentiality in general.
All right, lay it on me, Pete. How do we keep those client secrets locked up tighter than a bear-proof cooler?
Well, it starts with implementing robust confidentiality safeguards. This includes establishing physical security measures for confidential information, like locked filing cabinets and secure office spaces. You also need to implement digital security protocols for electronic records, such as encrypted databases and secure networks.
So it's like setting up a good campsite. You got to protect yourself from the elements and the critters, right?
That's one way to think about it, I suppose, but it's more than just physical and digital security. You also need to provide comprehensive staff training on confidentiality procedures and regularly audit and monitor confidentiality compliance.
Gotcha. And I bet you got to be extra careful in different settings, right? Like group therapy sessions or shared office spaces.
Exactly, Crash. Managing confidentiality in various clinical settings is crucial. This includes group therapy sessions, shared office spaces, telepsychology services, and even emergency situations. Each of these scenarios presents unique challenges to maintaining confidentiality.
All right, Uber School listeners, here's another question for ya. In a group therapy session, which of the following is true regarding confidentiality?
Great question, Crash. Here are the options. A, the therapist can guarantee complete confidentiality. B, group members are not bound by confidentiality rules. C, the therapist should discuss confidentiality at the beginning of the group. D, confidentiality doesn't apply in group settings.
Think it over, folks. We'll be back with the answer faster than a squirrel up a tree.
And we're back. The correct answer is C. The therapist should discuss confidentiality at the beginning of the group. While the therapist is bound by confidentiality, they can't guarantee other group members will maintain it. That's why it's crucial to discuss this at the outset.
Right on, Pete. Now, what about when the confidentiality dam has to break? You know, when you got to spill the beans?
You're referring to the limits of confidentiality, Crash, and yes, understanding when to breach confidentiality is crucial. Psychologists must be able to assess situations requiring mandatory reporting, apply ethical decision-making models for potential breaches, and implement risk assessment protocols for potential harm situations.
Sounds like a tightrope walk to me. How do you know when to take that step?
It can be challenging, Crash. Psychologists need to be well-versed in situations that require mandatory reporting, such as child abuse, elder abuse, or when a client poses a danger to themselves or others. It's also crucial to properly document any breaches of confidentiality.
And I bet you got to tell the clients about all this up front, right? Can't just spring it on them like a surprise fishing trip.
Absolutely. Effectively communicating the limits of confidentiality to clients is paramount. This involves explaining the limits clearly and at appropriate times, addressing any client concerns about these limits, and documenting all discussions about confidentiality limits.
All right, folks, time for another Uber School pop quiz. Which of the following is not typically considered a situation that may require a breach of confidentiality?
Here are the options, Uber School students. A client threatens to harm themselves. B, a client reports ongoing child abuse. C, a client admits to shoplifting a candy bar. D, a client threatens violence against an identifiable person.
Think it over, y'all. We'll be back with the answer quicker than a jackrabbit on a hot griddle.
And we're back. The correct answer is C. A client admits to shoplifting a candy bar. While illegal, this doesn't typically meet the threshold for breaching confidentiality. The other options involve potential harm to self or others, or ongoing abuse, which may necessitate breaking confidentiality.
Good stuff, Pete. Now, let's circle back to that HIPAA thing you mentioned earlier. What's the deal with that?
HIPAA compliance is a critical aspect of maintaining confidentiality, Crash. Psychologists need to implement HIPAA compliant practices, which includes adhering to the HIPAA privacy rule requirements, implementing HIPAA security rule strategies, managing business associate agreements, and following HIPAA breach notification procedures.
Sounds more complicated than setting up a multi-day campsite in grizzly country.
It can be complex, yes, and it doesn't stop at implementation. Psychologists are also responsible for HIPAA training and audits. This involves developing comprehensive training programs for staff, conducting regular internal HIPAA compliance audits, addressing any HIPAA violations promptly, and staying updated on changes to HIPAA regulations.
Phew, that's a lot to keep track of. But I guess that's why we're here at Uber School, right? To make sure our future psych stars are ready for anything.
Exactly, Crash. Now, let's move on to another crucial topic, mandated reporting. As a psychologist, you're a mandated reporter, which means you have a legal obligation to report certain situations.
Ah, the old see something, say something deal, right?
That's a simplification, but yes, psychologists must be able to identify mandated reporting situations, including child abuse and neglect, elder and dependent adult abuse, domestic violence, and dangerous clients.
And I bet there's a whole procedure for reporting this stuff, right? Can't just shout it from the mountaintops.
Definitely not, Crash. When such situations arise, psychologists must execute their reporting responsibilities by following procedures for contacting appropriate authorities, meeting documentation requirements for mandated reports, managing client relationships post-reporting, and understanding legal protections for mandated reporters.
Sounds like a delicate balance, Pete. How about we give our Uber School listeners another chance to test their knowledge?
Great idea, Crash. Here's the question. Which of the following is not typically considered a mandated reporting situation for psychologists?
All right, folks, here are your options. A, suspected child abuse. B, a client's admission of tax fraud. C, suspected elder abuse. D, a client's credible threat to harm others.
Take a moment to consider your answer. We'll be right back with the correct response.
And we're back, Uber School students. Pete, what's the verdict?
The correct answer is B, a client's admission of tax fraud. While illegal, tax fraud is not typically a mandated reporting situation for psychologists. The other options involve potential harm or abuse, which are generally mandated reporting situations.
Good to know. Now, what's next on our Uber School journey through the ethical wilderness?
Let's move on to our final topic, privilege. Psychotherapist-patient privilege is a legal concept that protects the confidentiality of communications between a licensed psychotherapist and their patient. Understanding privilege is crucial for ethical practice.
Privilege, huh? Sounds fancy. Is it like having a VIP pass to a client's thoughts?
Not quite, Crash. It's more about legal protection of the therapeutic relationship. Assessing privilege status in various clinical scenarios is a key skill. This includes understanding legal definitions of psychotherapist-patient privilege, privilege considerations in family and group therapy, the impact of third-party presence on privilege, and privilege in forensic and court-ordered evaluations.
Wow, that's a lot to keep track of. Sounds trickier than navigating a maze in the dark.
It can be complex, yes. Psychologists must also be prepared to manage privilege issues in legal proceedings. This includes responding to subpoenas for privileged information, asserting privilege in court testimonies, navigating privilege in child custody cases, and balancing legal demands with ethical obligations.
I bet there are times when this privilege thing doesn't apply, right? Like there's got to be some exceptions.
Absolutely, Crash. It's crucial to identify situations where privilege does not apply. These can include legal exceptions to psychotherapist-patient privilege, cases where privilege is waived by client actions, situations involving imminent danger, and multidisciplinary team settings.
And I'm guessing when these exceptions pop up, you can't just spill everything, right? There's got to be a proper way to handle it.
Correct. When privilege exceptions arise, psychologists must manage the disclosure of non-privileged information carefully. This involves following proper procedures for disclosure, minimizing disclosure of non-relevant information, notifying clients of privilege exceptions, and maintaining thorough documentation of privilege exceptions.
All right, Uber School listeners, one last quiz before we wrap this up. Which of the following does not typically constitute an exception to psychotherapist-patient privilege?
Here are the options. A, the client waives the privilege. B, the therapist needs to defend themselves in a malpractice suit. C, the client discusses their therapy in a public forum. D, the therapist wants to consult with a colleague about the case.
Think it over, folks. We'll be back with the answer quicker than a fish can swim upstream.
And we're back. The correct answer is D. The therapist wants to consult with a colleague about the case. While consultation is often necessary, it doesn't typically constitute an exception to privilege, especially if the client can be identified. The other options are situations where privilege might not apply or could be considered waived.
Well, folks, we've covered a lot of ground here at Uber School. From informed consent to confidentiality, HIPAA to mandated reporting, and all the way to privilege. It's been quite the journey.
Indeed it has, Crash. Remember, Uber School students, understanding these concepts is crucial for ethical and legal practice in psychology. They form the foundation of trust in the therapeutic relationship and protect both the client and the practitioner.
And don't forget, this material represents 20% of the California 2019 Psychology, Law, and Ethics examination. So study hard, folks.
Absolutely. We hope this Uber School session has been informative and helpful. Remember, every student who listens to this should be well prepared for the exam. Any final words, Crash?
Just that I believe in all of you, Uber School students. You've got this. Now, if you'll excuse me, I've got a date with a fishing rod and a peaceful lake.
Thanks, Crash. And thank you, everyone, for joining us for this Uber School production. Until next time, keep studying and stay ethical.